Again, welcome to Law and Life. Today we will be dealing with one of the important topic that is PIL, its evolution, importance, nature, misuse and safeguard. The senior advocate of Supreme Court of India will be explaining on this related topic. So my first question on the topic is, from the recent record of proceeding of Supreme Court of India, I find that the court is itself imposing heavy cost of rupees 1 lakh or even more for misuse of public interest litigation repetition, or is upholding such imposition of heavy cost by high courts for the benefits of all our viewers.
So let's take up all the things about PIL one by one.
Yes, sir.
So public interest litigation is a judicial innovation. If you look at the constitutional provisions, you will not find anywhere in the Constitution of India. But
Yes, sir.
now it has become one of the most important parts of India's constitutional jurisprudence. It is exercised by the Supreme Court under Article 32 of the Constitution and by the High Courts under Article 226. Its evolution started from 1980s when Justices P.N. Bhagwati and V.R. Krishna Iyer started entertaining letters from jails and public spirited citizens for redressal of violation of human rights and enforcement of other fundamental rights to life, liberty, and equality, and for protection of environment. Justice Bhagwati especially used it for the enforcement of environment.
Yes, sir. Sir, how is PIL different from the enforcement of fundamental rights under Part 3 of the Constitution?
It is different in one particular aspect, which I must emphasize, and that is locus standi of the petitioner. So, for understanding this, let us go a little in the background. Most of the legal systems prevalent in the Western countries require a litigant challenging a government action to show his direct personal interest, in the subject matter of the litigation. So, in legal parlance, this is called locus standi. Broadly speaking, the term locus standi denotes legal capacity to institute a case in a court of law. The court asks the litigant what standing or right he has to seek that kind of relief. This is because the judicial power is limited to deciding a case or controversy. But a celebrated British judge, Lord Denning, in his very famous work called The Discipline of Law, published in 1979, tells us, so I'm quoting,
Yes, sir.
in recent years there have been a remarkable series of cases in which private persons have come to the court and have been heard. There is now much wider concept of locus standi when complaint is made against a public authority. It extends to anyone who is not a mere busybody but is coming to the court on behalf of the public at large. So, and then he gives the instance of one particular person called Raymond Blackburn, who was a member of parliament.
Yes, sir.
So, Mr. Blackburn, uh, from 1966 onwards, brought a series of high profile cases. So, these cases related to, you know, the bad effect which gaming clubs of London were having. Then he raised the issue of pornography in a locality called Soho
Yes,
in
sir.
London, and censorship being exercised by Greater London Corporation. And lastly, the Britain's accession to the European Common Market. So, with his concise and pinpointed advocacy, he always succeeded. This is very important. So Mr. Blackburn thus succeeded in enlarging the scope of locus standi for the purpose of issuing the prerogative writs, which are also mentioned in our Article 32 and
True.
226. of the Constitution.
Yes, sir.
So, thus, we can broadly say that public interest litigation enlarges the scope of locus standi and enables a public spirited citizen to file and pursue writ petitions in the Supreme Court and the High Courts to seek relief not on behalf of himself but for the benefit of persons belonging to the marginalized sections of the society.
Sir, what is the importance and nature of PIL?
Uh, about the importance and nature of the public interest litigation, it is best to quote two part paras of the judgment of Supreme Court in a case called People's Union for Democratic Rights versus Union of India, which is reported in 1982, 3 SCC at page 235. So let me first say about the importance. So this is a quote. PIL is brought before the court not for the purpose of enforcing the right of one individual against another, as it happens in the case of ordinary litigation, but it is intended to promote public interest, which demands that violations of constitutional and legal rights of large number of people who are poor, ignorant, or in a socially and economically disadvantaged position should not go unnoticed or unredressed. That would be destructive of the rule of law, which forms one of the essential elements of public interest in any democratic form of government. As regards the nature of public interest litigation, it has to be noted that it is not adversarial. This same judgment of People's Union of Democratic Rights case holds that public interest litigation is a cooperative and collaborative effort. So mind this, note this,
Yes, sir.
cooperative and collaborative effort on the part of the petitioner, the state, or the public authority and the court to secure observance of constitutional or human rights, legal rights, benefits and privileges conferred upon the vulnerable sections of the community. So I think I have answered your question.
Yes, sir. Sir, what are the misuse of PIL and what measures have been taken for the preventing its misuse?
It is true that after the public interest litigation became an established type of litigation, there has been mass misuse. So misuse of public interest litigation as a judicial process was also noticed by the Supreme Court in several cases. And let me paraphrase some of the, uh, because quotations may not be possible.
Yes, sir.
So I'll uh, kind of paraphrase. So, in a
Of course,
case
sir.
called Alimuddin versus State of UP, which is reported in 2020 18 SCC 419, it has been said like this. When it is used to subserve personal interest of the petitioner or for his extraneous or motivated purpose, then it's a misuse.
Yes,
Then,
sir.
in another case called Kusumlata versus Union of India, this is what has been held. Where material on record shows that public interest litigation is camouflaged to foster personal disputes, it's a misuse. In another case called Janta Dal versus H.S. Chaudhary, reported in 1992 4 SCC 305, the Supreme Court pointed out that public interest litigation has come to occupy an important place in the administration of justice and should not be allowed to degenerate into private interest litigation or publicity interest litigation or political interest litigation or Praise interest litigation. If it is not regulated, it can become a tool in the hands of unscrupulous people to wreak vengeance or release vendetta. Courts of justice cannot allow the public interest litigation to be polluted in this manner. Lastly, I'll quote, from Ramjas Foundation versus Union of India, which is reported in 1993, Supplement 2 SCC, page 20, where Supreme Court pointed out that even as every writ petitioner is expected to come to the court with clean hands, the petitioner in a public interest litigation is expected to come to the court not only with the clean hands, but clean heart and clean mind and clean object.
Yes, sir.
So, uh, there is another case which I would like to quote, and that is State of Uttarakhand versus Balwant Singh. That is reported in 2010 3 SCC 402. There, the Supreme Court gave a series of directions to curb the misuse of public interest litigation. So, uh, let us see what are the. So, it has been directed to the high courts that they should encourage public interest litigation by filing of genuine public interest litigation
Yes, sir.
petitions. Secondly, discouraging the filing of spurious PILs, which includes, imposition of high costs, about which you spoke in the beginning of this episode.
Yes, sir. Yes, sir.
And thirdly, formulating rules by the high courts instead of dealing, instead of each judge, each judge or each bench dealing with the public interest litigation in its own manner, different manner. I, Lastly, I would like to say before concluding this episode that Supreme Court itself has uh, framed rules 12 and 13 of Order 38 of the Supreme Court rules 2013 to scrutinize every public interest litigation. The petitioner in a public interest litigation before the Supreme Court has to give an affidavit setting out many of these things which I described.
Yes, sir.
And Supreme Court has also assumed the power to impose exemplary costs.
Yes, sir. So it was very important topic for all the viewers, and thank you, sir, in giving us such knowledgeable session. And that's all for the day, sir. We will see you in the next episode, sir.
Yeah. Thank you.
Thank you. Thank you, sir.